This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviat. Tonight we're taking your calls and questions about liquor and the law. So tonight we're going to talk about local bars, the laws that govern local liquor licenses, liability for those establishments. Some of you here tonight may go to those establishments regularly. Some of you may be totally opposed to it. Well, tonight's your chance to speak up and talk about some things going on, morality, legality, and laws that affect these establishments. Call in your questions, the 31 Law Call number 256-536-0077. You can also email a question. You can email a question any day of the week on any legal topic. You send it to lawcall@waaytv.com. And when we get to a show that's on point, we will pull some out. We've got some of your email questions tonight. Will League is here from Timberlake, League and Brooks. Tonight we're talking about liquor and the law. A little different.
You know what? A lot of topics within that title. What we usually see at our firm is someone who's overserved or contrary to the provisions of law. They're served while they're visibly intoxicated, leave the bar, hurt someone in a vehicle, and then it's a dram shop case in addition to just a regular automobile wreck case with regard to insurance. The bar has insurance to cover that. So a lot of things that we look at in that particular area. We're also going to talk about assault and battery in law. I mean, in bars, but also there was in the local news, two gentlemen's clubs were denied liquor licenses in Madison County. Okay. What are the laws surrounding that? What do they have to do to get a liquor license, and what are the requirements for that? Good. You know, sure are.
We like to start the show off with a little video for you. So let's show you tonight's You Make the Law Call. We pull this off of YouTube. This is a case, you know, folks out having a good time at the club and then a fight breaks out.
You know, and we're lucky to have one of those participants in the studio with us tonight. So Eric Artrip is the one in the hat to the left. And so as you can see, he's in there making trouble.
You're starting something.
So the question
this is not Eric.
You're in there, you're minding your own business, and then Eric Artrip starts some trouble. What's the liability? You got security coming in. Well, we don't have security. So what's the liability of the bouncers? What about the people who are fighting this?
And this one just gets worse and worse. More people pile on. Yeah,
not
what
good.
a mess.
Not good. So, you know, if you actively engage in this conduct, you know, let's say you start the fight, you start this altercation, is there any liability? Yeah, there is. You know, if you cause or contribute to this, you can be liable for anything anything you cause, any damage you cause. Eric, you were in the middle of it. Tell us a little bit about that.
No, that wasn't me.
that wasn't you in there?
That guy had more hair than me.
Okay. Well, so, you know, handle assault and battery cases in a bar, mind your own business, two other people getting in a fight, and then it kind of spills over and hurts you or your client. How does that work, Eric?
Right. So, you know, as we both know, that the law is broken up into criminal law and civil law. Same punch across the nose can result in criminal penalties and then civil remedies. And civil remedies is what, you know, obviously Will and I specialize in, and that's where we would talk about compensatory damages like medical bills, time missed off from work, pain and suffering, mental anguish, these kind of things. And so if somebody throws a punch while they might be prosecuted criminally or not, they can also be liable in a court of law for civil remedies.
You know, and then the next question is the bar liable?
Right, because they're serving.
Let's say, I mean, I've had gunshot cases in bars where, let's say you had a gun fired on Monday, Tuesday, Wednesday, Thursday, and then you fail to get any type of security. Yeah. So typically the law in Alabama is you're not liable for criminal acts of third parties unless and until it's foreseeable and you fail to do anything to protect your patrons. So in the traditional question, was it foreseeable from the standpoint of the bar owner or the staff or the bouncers? And if it was, then there could be some liability. Obviously, the criminal who is engaging in this conduct causes the damage. He or she is liable as well. The bar could be liable if it's foreseeable, and you know that's how the law typically handles those situations when the bar does something or doesn't do something to protect their patrons and some misconduct happens.
So what are bar owners and bartenders supposed to be looking for? If people are in there and they're drinking, I mean, you sell, so you expect people to be drinking. What are they looking for that crosses the line to make them responsible potentially for something that happens?
I think just like Will said, it's foreseeability. And if somebody's visibly intoxicated and you continue to serve them beer, shots, drinks, what have you, at some point the bar is going to develop some responsibility for that person's conduct. And that's, Will's firm does a lot of dram shop actions. That's like a fancy name for, I left the bar intoxicated, I got into a car accident, I hurt somebody.
So how far are we talking? You're responsible for paying for all of their injuries? I mean,
that's right.
The whole thing?
And
maybe?
Assault case, okay, in a bar, there's a fight, and the person's injured. There's criminal, like there's criminal case for assault and battery. There's also civil for compensatory damages, pain and suffering, medical bills, things like that. Sometimes you can recover it, sometimes you can't. There's no insurance. If it's an intentional act, if it's an intentional injury, your insurance at home will not cover you. But let's say you're out, you're dancing, you're having a good time, you get a little too crazy and you fall into the table next to you. If it's an accident, your homeowner's insurance will cover you for the damage you cause if it's accidental. You pull out a gun and shoot somebody, that's intentional conduct, you won't be covered. Let's say you pull out a gun and try and shoot person A, accidentally shoot person B. You may be covered under that circumstance depending on how the defendant's homeowner's insurance policy is written.
How do you prove your case? I mean, the video that we were just talking about, maybe you're lucky enough that the facility you're at has got video. I bet a lot do not.
They don't. I mean, eyewitness testimony.
Okay.
A lot of times you have video. The police will come in, oftentimes do a report, get witness statements, and you can look at those reports to see. Now remember, the criminal case goes first. Remember in O.J. Simpson, he was tried criminally first, was found not guilty, but he was found guilty in the civil trial for wrongful death. And so criminal goes first, and then civil usually goes second.
Okay, and then we've got some new efforts with different locations trying to get licenses, right? Some liquor licenses.
That's right, yeah.
And lawsuits over not being allowed to have liquor licenses. So that kind of goes the whole other direction, right? Tell me about that case.
Yeah, potential cases, obviously, because there were 2 gentlemen's clubs here. There's 5 in Madison County. There was 2 that were applying for liquor license. They already have a beer and wine license, so they can already sell those things. And I think most people will be surprised to find out that you can't get a drink in some of these different clubs. But the Madison County Commission, you have to apply for a liquor license. They have to approve it. These 2 establishments made application and they were denied. And it seems like the denial may have been more based on the kind of business they were than maybe what the paperwork would indicate.
Okay.
Now let's break that down. So you got a restaurant or a bar, and you want to serve, in addition to beer and wine, you want to serve whiskey or liquor.
That's right.
So you have to apply to get a license. And so your clients it's a gentleman's club, right?
That's right.
And so there's a First Amendment protection of freedom of expression. It could be artistic, however, whatever degree. And if it fits that category, the government can't come in and shut you down as that would be a violation of the First Amendment rights of the club. Now, that differs in that the club is now applying for a liquor license. And some of the guidelines say you have to either provide food or there has to be some level of dress, or you can't be fully undressed. What's the standard?
Yeah, so the standard for getting a liquor license in Madison County is basically you have to have 50% or more of food sales. And these establishments say we've established that, we've proven that through our receipts and things like that. But those licensors were denied them regardless of that fact, and it does seem that it was more about the kind of business that they were operating, and that's really what some people say would not be fair is when you have an elected official who says, well, even though they meet the guidelines and things like that, we're just not going to have these because we don't like it. Well, that's them putting their personal opinion in things, and that's against the law.
All right, so with the argument from there would be that if they were to say, okay, we're not doing it because of the kind of establishment it is, gentleman's club, and we seem that may be obscene. And so the determination of whether or not it's obscene material or not would go directly to the First Amendment. If it's not obscene under the community standards, then it would pass. If it is, then it would not, correct? Right.
I mean, there's nothing in the liquor license or liquor statute which says you can't have a strip club or you can't have a gentleman's club or you can't have, erotic dancing or anything like that. It doesn't say anything about that. All it says is you have to have more than 50% food sales and you have to submit paperwork which would prove that. And even though these establishments seem to have done that, and they were still denied a liquor license, and ultimately that may be found to be a violation of their constitutional rights.
Okay.
You know, and we're seeing a lot of free speech with Donald Trump, right?
Yeah.
Political speech is usually protected unless it incites violence, and that's what's going on with the Supreme Court right now. That you can talk about overthrowing the government, but you cannot say words that's going to spring people into action to actually do that. So that's the difference the Supreme Court is going to look at.
They're telling us to take a break. We're going to take a break. Be right back answering more of your questions about liquor and the law. Stay with us.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Meservey. And hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Doviet. Tonight we're talking about liquor and the law. A little bit different, talking about the responsibility that establishments have when they're serving alcohol, or that you may have if you have a party and you're serving. Can you be held responsible for something that happens? We've got both Eric Artrup, who is with Mustando and Artrup and handling some interesting cases along this line, and Will League from Timberlake, League & Brooks. They're personal injury attorneys, so everything from assault cases where somebody gets hurt in a bar, or car accident after somebody has been overserved.
You know, and Sharon, we usually get somebody calling, I was hit by a drunk driver.
Yeah.
And so we'll look at the police report, we'll do the investigation, get all the witness statements, things like that. But oftentimes, where was that driver? Was he or she at a bar? Where did they drink? Did they pay by cash, credit card? Look at all those things to see if that person was possibly served contrary to the provisions of law, i.e. dram shop cases. And if you've been hit by a drunk driver, give us a call tonight. We'd like to hear your experience and how that went, and if you went and testified in the criminal case or the DUI case.
Eric, tell us a little bit about what you've host liabilities. If I throw a party at my house, am I held to the same responsibilities and the same level as like a bar that's got bouncers and people who are checking everybody? How worried do I need to be about my guests?
I don't know, but I think the answer is potentially, because when you're throwing a party, if you're having a whole bunch of people at your place, you've got a whole bunch of liquor there and you're letting them have free reign to it. If they get out on the roads and drive afterwards, then yeah, if they cause an injury or an accident or something along those lines, you actually can be held liable. So usually what Will and I would tell our clients is, if you're going to throw a party or something along those lines and you're going to have free access to liquor, that's fine. There's nothing wrong with that. But you might want to think about having a bowl where people throw their keys and make sure that everybody's Ubering home or taking a lift.
We got in this email question. This is from D. D wrote in and said, my friend got assaulted outside a club. The drunks are always hanging out there and nothing's ever done. The manager told her he's sorry about what happened, but that is it. Can my friend take any legal action outside the club?
All right, so we've looked at these cases as well, and I don't know what it is, or maybe it's tried and tested, but youth and alcohol is a problem. You know, things happen. But in this case, Dee was outside. The drunks are always outside the bar. If they're causing trouble, is the owner or manager on notice of that? So that's one level. Yeah. Obviously, you described them as drunks. Obviously, the damage and injuries they cause, they're not only criminally but civilly liable. Okay. And you can have your medical bills, pain and suffering, things like that. The question is, can you recover it? And let's be honest, most folks that are assaulting folks,
drunk outside a bar, do not have resources.
A lot of times they're limited in what you can recover, so let's be honest. So oftentimes the only recourse is criminally. And talk to the district attorney's office, they'll prosecute that case, see what kind of evidence you have. But potentially the manager and the bar could be liable if they're on notice of criminal acts and it's reasonably foreseeable and they fail to protect their patrons. They know people are coming in and out of there. And the level of damages, we've got a drawer full of verdicts on these cases, but again, is there insurance or assets to back them up? And, Eric, we'll get these big verdicts and, are they worth anything? That's the question.
That's right. Sometimes they're just a paper tiger because the person doesn't have any assets to actually pay off a judgment or a verdict against them. So, just like Sharon was saying before, we can we can prove any case in either one of two ways, circumstantial evidence or direct evidence. And either one of those two things could put somebody in that bar being overserved, and then they step outside and then it physically assault somebody. If they were overserved at the time in that bar, you might be able to hold that bar accountable. But it really comes down to, was there direct evidence that they were served an alcoholic drink when they were visibly intoxicated at the time they were served it?
You know, in the training the bartenders have got, you know, you're a bartender for X amount of time,
Yeah.
you know somebody's hammered, can you still continue to sell them shots? And that's contrary to provisions of law. Sometimes we'll take these depositions and these bartenders have zero training to determine how much, you know, how much is on this particular credit card, how much is this particular person drinking. But again, to their defense, maybe this guy can handle his liquor more than someone else. Maybe they can't. So, and I'm not trying to say it's an achievement, but the bartender, him or her, may not know exactly that person's tolerance, what their BAC level is. But if the standard is if they're visibly intoxicated, you got to cut them off, and that's Alabama law. And you know, don't want to be the bummer, but when you're representing people that are hurt and killed, it gets serious real quick.
And we've got Ubers and taxis. It's so easy to get a ride home in Madison County. We've got Phil on the line with a question from Madison. Hi, Phil. Thanks for calling. What's your question tonight?
Hey, good evening. Thank you for taking my call.
Sure.
With regard to high school and college athletic events, in the cases of tailgating and drinking and partying at these athletic events, in the case of someone getting hurt, are the universities or local school systems liable for those kind of problems with regard to drinking and alcohol and such things?
Very interesting. They
Interesting
certainly
question.
encourage the partying, don't they?
You know, hey, and they're benefiting, everybody's out there for the game, let's
Yeah.
buy more beer, things like that. You know, if the school does not provide the alcohol, similar to the social host that Eric was talking about just a moment ago, if the school doesn't provide the alcohol, although they do provide the venue, they're probably not going to be liable. But again, every fact scenario is different. Let's say they know people are drinking in there. They know that they're tailgating, everybody's too intoxicated. But again, they didn't provide it, but this criminal activity is foreseeable from their standpoint. Let's say something like this happened last week, the week before.
Yeah.
They didn't do anything to protect the people in the stadium or in the parking lot. It's plausible theory that they could be liable. You know, Eric, the schools benefit from this. There could be an argument that, okay, they encourage people to come in this parking lot. They provide security.
Right.
They don't do anything to see if minors are being served. So in case of a minor goes in there getting alcohol on campus and then hurts somebody or gets hurt themselves, what's the liability there?
I think it's a really interesting question because this is usually taking place on a college campus where they have control of the property. And so they should, have security. They should have police around there kind of making sure that people are being safe and just there to have a good time. But it's also true, just like Will said at the beginning of the show, that generally speaking, people aren't liable for the criminal acts of other people. So if somebody actually, they break the law, they're drinking underage. They break the law, they start a fight. They break the law by getting in their car and getting into an accident. Typically, it's very hard to hold somebody else accountable for that kind of behavior.
Mm-hmm.
We've got Pete on the line with a question from Gurley. Hi, Pete. Thanks for calling. What's your question tonight?
Yes, ma'am. I was wondering about, I have parties over here before I retire,
Uh-huh.
and a friend of mine brings liquor. I don't have no liquor on my property, but what I do, we do drug beer and stuff at my parties. But would I be reliable for people that got drunk on somebody else's liquor?
It's at your house, but somebody else brought the liquor.
So they're coming to your house, you got some beer, you're not providing any liquor, but the person who came got drunk on liquor and somebody else brought it, right?
That's what I heard.
Yep, that's what I heard too.
What do you think, Eric?
Yeah.
I think that's it kind of puts you in the exact same position as if you were giving it to them yourselves, because if you're letting somebody drink at your house, have uninhibited access to whatever liquor they want to drink, and then you see them leave, grab their keys and get out on the road to drive, it's your house. You had the ability to stop them. If you didn't, that may be one of those limited exceptions to holding somebody accountable for the criminal acts of another. is when you had the ability to stop them and you didn't stop them and then they hurt somebody, that can be problematic for the host.
Let's talk a little bit about underage drinking at your house, right? So if your teenagers have other teenagers over and they're drinking alcohol at your house, okay, it's one thing if you don't know, it's another thing if you know or you suspect.
Yeah, I mean, don't be the cool parent.
Okay.
Because you can be liable. You know, remember when we were kids, your parents said, "Oh, you can't if you hurt somebody in the car, they'll sue us for everything." Well, that's not the case. The parents have to do something to cause or contribute to that wreck or do something negligent themselves. However, if you're a host, just like Eric mentioned earlier, and you provide or allow access to alcohol on your premises contrary to the provisions of law, a minor, they go out and hurt themselves or somebody else, you could be liable not only civilly but criminally. And that's tough stuff. You know, it is the blood alcohol content for a minor is 0.04, so it's lower.
Yeah.
And it's easier to get a DUI, but you can be liable. So social hosts, be careful. Don't be the cool parent. And, you know, you want to try and monitor as much as you can. But again, you allow people to drink on your property, there's all types of liability that comes along and responsibility that comes along with that.
Let's talk a little bit about the amount of time. You've got a pretty good statute of limitations on cases like this, but if you wait until the last minute to try and do something to prove that the bartender overserved, you've waited way too long, right? Talk a little bit about hiring a lawyer, going to see a lawyer, time frame for cases.
Generally speaking, it's 2 years.
Okay.
So in Alabama, we have 2 years in order to do that. People should not wait. They should definitely, pick up the phone and talk to somebody like, somebody who's going to be able to tell you a little bit more about what your legal rights are, and then obviously send a letter to the bar to secure the video footage so that they don't throw it away, because typically those things are disappear in 30 days. Mm-hmm. So you got to act really quickly.
Mm-hmm.
Okay. Thanks for all your questions. Let's take a break. Be right back answering more of your questions all about liquor and the law. Stay with us. If you didn't get your questions answered tonight, here's how you can get in touch with Eric Artrup. He is with Mastando and Artrup in Huntsville, 256-532-2222. Check out mastandoartrup.com. Here's how to get in touch with Will League with Timberlake, League & Brooks in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com, and you can like them on Facebook and learn more about the law that way.
And our very own Sharon Doviet, family law attorney, Huntsville, Alabama, 539-7337. Divorce, child custody, SharonFamilyLaw.com.
And you guys have got a blog about
right.
some of this that we're talking about.
Want some more information on liquor liability, dram shop cases? Look at our blog at Timberlake, League & Brooks, and you can actually scroll down liquor liability, dram shop. And actually the 3 drunkest holidays surprised me was New Year's Eve. Well, that's St. Patty's Day and Thanksgiving. Everybody's getting it done on Thanksgiving. So yeah, be careful and check out our blog.
Thanks for all your calls and questions. We'll see you next week.